Welcome back to the Legal Alternative Podcast. Me, Sam Pawson, joined as ever by Nils. Nils, how are you?
I'm good. I'm glad it's cooled down.
Yes.
It was too hot.
Me and you both. I'll share my weekend exploits of being bitten. But yeah, it's much cooler today, a day of recording. So yeah, even wearing long sleeves. So
Yeah.
bit of a change. Nils, what we got coming up today?
So I think we're both gonna go into quite a bit of depth today, aren't we?
Yeah.
So you're gonna recap the year as a whole.
Yeah.
I'm gonna talk about the proposals in immigration law a little bit, but in the context of typical problems we find during recruitment with immigration law. Then we're going to talk about what's going on outside the office. So an exciting event coming up next week. And then I think we've got a really interesting question to close off with.
We do. So I think it's worth mentioning this is probably last podcast of the summer in this format. Might do something next week, a bit different. So this is last major update until probably September. So good opportunities for both to kind of recap where we are. And I think you're going first.
Yeah. So I just thought it'd be good to end the season, so to speak, just bringing together a lot of the stuff we spoke about in terms of immigration law. So just starting with the proposals, just to the reform that's going to take place on the 22nd of July, increasing the skills threshold, which we've discussed, increase the general salary threshold, closing social care visas, replacing the immigration salary list. There are going to be some further changes coming at the end of 2025, increasing the immigration skills charge by 32%, already quite expensive and going up again, and increasing the minimum English language requirements, including adult dependent relatives for the very first time. So some big changes coming in, and I just thought on the back of those changes, I just want to give some sort of top tips as to calls we get that are problems onboarding someone effectively from an immigration law point of view. So the first one is, are you establishing that the applicant actually has a right to work in the UK? And if you don't get that right, can have profound consequences. So a civil penalty of up to £60,000, potential criminal liability, and possibly the business being shut down for 48 hours. So it's really important that you get that onboarding correct. And you do that by identifying the correct type of right to work check. So you could do it online. There's a service there. There's also an identity service provider that you could use. And you could check documents physically. And it might be you have to check a biometric resident permit, a frontier permit, or an e-visa. If you're doing an online check, manual check should be where an individual doesn't have one of those documents, and that includes someone who's British or Irish in terms of being a passport holder. You've got to make sure, and this is the second top tip, that you carry out that right to work check correctly. It sounds an easy thing to do, but the manual check, it can be quite complicated. So it's important you go through the guidance that is freely available online to make sure you're doing that manual check correctly, including copying the documents and making sure you're recording the date of that check and any follow-up check that you're required to do. If you're doing the online check, it might just be a case of obtaining the share code and going through and checking that the photograph on the profile page that's generated matches the person that's actually presenting themselves for work. I was listening to the LBC in a rare weak moment because my son was playing on his phone on the way home. Couldn't listen to my usual podcast, which is obviously this one.
Yeah, obviously.
But there was the presenter was trying to make a big deal of takeaway drivers. Yeah. And he was saying how many times the person that turns up to the door is not the person that is displayed on the app. I don't know that that's going on in the workplace. If it is, people aren't coming to us, but it's not turning a blind eye if that does happen. I'm sure it does happen. And returning a copy of that check. In terms of other things that could go wrong, preventing discrimination comes more into your area. So I won't talk too much about that, but it's ensuring that you are considering the content of your adverts, right to work applications, not being discriminated against if that person isn't a British or Irish passport holder. So that's another area where we see it go wrong. Another area where we see it go awry is where someone's applying for a license, applies for the license, and then he's checking whether the migrant actually has the ability to work in the UK. Do it back to front. Make sure you're checking the eligibility criteria first of all. Beyond that, making sure you pay the correct immigration health surcharge, making sure that your offer of employment and your employment contracts is all okay. Not our bag. Are there any tax issues? Is someone had experience where someone's working 2 or 3 days a week in the UK, 1 day a week in Ireland, the rest in wherever in Europe? And of course, making sure that accompanying family members are a consideration if you're going to sponsor someone. Are you going to sponsor them? Is the migrant going to sponsor someone?
Yeah.
So it's a whistle-stop tour of typical issues that we see go right or wrong during the process.
Absolutely. And you say some touch on my area, and I think it's that, it's sorting out that initial burden on time. That goes to employment in terms of employment contracts day one. But as you say, I often see right to work checks might be done but not done correctly in the time frame, and I think you said that review. I think that gets missed, doesn't it? Where we might have an initial right to work that might expire, and is that review process actually undertaken?
Absolutely, yeah. It's critical. It's an ongoing duty.
Yeah,
it's not something we've got the visa, let's forget about it, or the check, rather.
Yeah.
Sorry.
But I think that's sometimes what happens. People think, oh, actually, I've sorted that out.
Yeah,
don't need to do anything. So yeah, absolutely. Whatever that system is that you've got in place, your management flags, a lot of good software now for HR that should be able to flag up those types of issues.
Exactly.
Check your visa. So make sure you're on top of it, and always good advice as always.
Yeah, good stuff.
Similar vein, Nils, I'm going to do a bit of a recap in terms of what we've got coming up. So conscious that we're getting drip-fed announcements at the moment in terms of Employment Rights Act. So we talked last week about banning of NDAs and settlement agreements. So things are getting dripped out from the Employment Rights Act, and the vast amount of changes that were mooted probably a year ago, which we've talked about most of them on the podcast. So I don't want to go into much detail, but to try and give a bit of a roadmap, perhaps, of what we will expect. Obviously, if something critical comes in over the summer, we'll update on specific points. But to try and give the listeners a bit of an understanding of what's to come up. So I'll go through them in turns. I'll get my column on my phone. So we're going to see apparently a raft of changes in October 26, and then some probably with no time frame in 27. To be honest, I'll mention them when we talk about them. Some of them I don't think, if it's 27, I think that will be, we'll be lucky. I think it will be either never or even further afield. So I'll go through them quickly in terms. As I say, we have mentioned most of them. So October 26, apparently we are going to see what the government calls an ending of unscrupulous fire and rehire practice. So fire and rehire, as I've gone a bit on my soapbox about this before, of something I actually don't think is a huge issue. It got lots of attention from the P&O Ferries case. We're going to have a legal means of a dismissal in terms of SOSR, which fire and rehire is part of. What I think we'll see is some form of watering down of what they've committed to. So they'll allow some form of dismissals on termination and re-engagement, but it's this, what they say, unscrupulous. So it will be some restrictions on offering re-engagement, I think, is the way they'll go. Or you can't automatically expect someone to have re-engagement and that dismissal to be fair. There'll be something around that. But I think it's going to be really difficult, and that's why I say I don't see the huge problem here, because it's still subject to a fair dismissal. So fire and rehire it's not an automatically fair dismissal. You have to go through a process that has to be justified. So the P&O Ferries, the companies who've done them, those dismissals weren't fair. They got a lot of headlines because of the manner in which they were done, but they were still unfair dismissals ultimately. So something apparently coming in October 26 on that. Next two that both similar were in the world of sexual harassment again. So what we talked about when these changes came in last October, that those original processes that actually were brought in by the last government, there was a slight change in the language, which originally was going to require employers to take all reasonable steps. We just have to take reasonable steps now. What apparently is coming in is that that language is going to be reintroduced. So all reasonable steps again, which is going to place a real burden on employers. What all reasonable steps will be, we'll see, but it's really putting a burden on employers that if any sexual harassment goes on in your organisation, it's not going to be tolerated. But there's essentially no defence, because there's always going to be something more you can do, in my view. So if all reasonable steps, that creates such a high threshold because there's always going to be something you can do. So how that will be determined, I think, is going to be very difficult. But that is apparently what is coming in.
That's a really interesting point. Sorry to butt in.
No,
I've never thought about it in these terms.
reverse it, yeah.
But that reminds me of the health and safety cases that we do, in that all you have to do to win a prosecution there is say, well, you didn't do that, and it's game over. Yeah. And that's why it's virtually impossible to defend a health and safety claim. And I think that's going to apply.
I can, on face value, I think that's the only way that it can be. And I think that's why it was changed. So that will be very, we'll see if that does come in, because I think it will create some real difficulties. Similarly, with that, the other introduction apparently in October is we're going to go back to an old piece of law, which was third-party harassment. So third-party harassment is going to apparently come back. So the duty again on your employer, not just to protect your employees from other employees, but from third parties, so clients, customers. Again, probably it's something that has been historically the case. So I can see more logic in that, and I can see how that, as long as that is subject to the same measurements as it is now, that makes sense, that you should protect your employees from harassment from third parties. I think that is logical. If that comes in with the all reasonable steps, we're in the same issues. Yeah. So 2 on third party, 2 on harassment, 1 on firing and rehire, apparently coming October 26th. So let's say, I will stress it apparently. 27, I'll go for much quicker. Some changes to gender pay gap reporting in terms of requirements, menopause action plans, promote gender equality. So further information around there. Enhanced protections for pregnant women and new mothers during maternity and paternity leave. At the moment, obviously, when we've got redundancies, we've got protections in terms of, if there is alternative roles, the favouritism for those roles, we're going to see some further enhanced protections that will probably make it very difficult, if not impossible, to terminate anyone's while they're on maternity or paternity leave. We'll see how that will come in. Bereavement leave, we've talked about previously. Again, some enhanced protections around bereavement leave. Improving access to flexible working, again, is something that is constantly discussed. Again, is there a great deal that needs to be changed? In my view, no. Ultimately, at the moment, we've got a right to request flexible working. So unless you want to change the law to make flexible working itself a requirement, that's the only thing you can do at the moment. The system, I personally believe, works quite well. We've talked about before this kind of what's now become it's almost like Brexit. It's the hot LinkedIn debate, which seems to have no middle ground. You're either pro work from home or you're pro work from the office. There seems to be no middle ground here. So people are very passionate about it. We'll see what happens there. And the big one, finally, as I say, which I will be shocked if it is within the year, is the idea of day one rights against unfair dismissal. So removing the 2-year the 2-year gap, or the 2-year requirement, obviously, for service for a claim, making that a day one right. It is still part of the Employment Rights Act. When we'll see it, I don't know. As we've discussed previously, Nils, I personally, again, my own view, the tribunal system at the moment is not geared up for it. We are still routinely in our litigation team seeing preliminary hearings, full hearings 2 years in advance. So I can't see how any assessment of day one rights isn't going to increase the burden on the tribunal. Can the tribunal handle that? In my view, at the moment, it can't. We'll see on that. There is still a lot of consultation about over probationary periods and how that is going to interact with this day one rights. So again, I think there's still a lot to do before we're anywhere close to bringing this in. But as we've talked about previously, that would be a complete game changer if it does come in. Yeah. So a bit of a whistle-stop tour. As I say, pick some things out. I don't know, Nils, anything else you wanted to?
It's all interesting stuff, isn't it? I think what business would like is clarity, wouldn't it? Yeah. Because at the moment there's not a huge amount really changed, is there?
There's not. So again, with always our caveat about being political, but the announcements around the time of the largest changes to labour law and employment law, absolutely, if they come into force, it would be. We're not there yet. Yeah. Out of the office, I've got something. By the time we've recorded, or this comes out next week, I'll be at our annual Aspire touch rugby at Headingley Stadium. Always a highlight year to year. You've done it at least twice.
I got a silver medal one year.
You did. I remember. So as you know, Nils, always a highlight. Working with SPA customers, adults with learning difficulties on the pitch and head, absolute highlight of the year. Something we enjoy every year. So that'll be fantastic. And we've both been out about, as I say, in the heat. One of the reasons I'm not in shorts is my legs have been bitten to the inch of their lives camping in Ripon, which was lovely. But what have you been up to?
Well, I was thinking this morning, gearing up for the football season.
We are
looking to buy tickets for Huddersfield Town away at Bradford City. And I think by the time we get round to sort of the new season, if you like, after the summer break, the football season will be underway.
Yes, the women's Euros at the moment, obviously. I saw the England-Wales game the other day, which was brilliant. But as you say, it seems wrong in a way to be planning our team's fixtures. To say I've got done the Barnsley games and they're coming around. Barnsley Huddersfield is probably going to be played by the time we're back. So, football season upon us.
Good stuff.
Question. I think you've got a question came from one of your sources.
I have, really interesting one. And if an individual has been signed off work sick, but will be doing some light duties on odd days, how do the pay arrangements work for that?
Yeah. And we both give our views. And the short answer is if they are working, they need to be paid. Yeah. There is some technicality in terms of are they fit to work? Because strictly speaking, if you've got a fit note, that's saying you're fit to work within a period. So I think the question, if I understand it correctly, is they've probably got a fit note that says 2 weeks, but they're going to work shifts in between. So technically the fit note should cater for that. And if it doesn't, they are arguably not fit for work. So we've got some competing issues here for me. If they are working, they need to be paid. Arguably, if they've got a fit note that says they're not fit for work, they should be going back to clarify that, because who generally determines someone's fit to work if you are not self-certifying is obviously a medical expert. So common question we both get is when people come back prior to fit notes expiring, do companies have personal injury liability, things like that? So it's slightly grey area, but so absolute belt and braces, get them to go back to the doctor and say, I am capable of doing
X, Y, and Z.
X, Y, and Z. But absolutely, if they are working, they need to be paid, even if they then go back and are subsequently not fit, because you do get that quite commonly, intermittent absence, where either through a long-term condition where people have days in which they're not fit to work, but then days they're feeling better. So yeah, absolutely make sure you're paying them, and what you can't do is pay them SSP when they're working. Yeah. But to look at that either day by day, they're fit one day, they're not fit that day. When you're self-certifying, that's easier. Point on SSP to think about, though, if you are paying SSP, is if they do return, how do those waiting days work in terms of payment for SSP? If it is a connected absence, you don't have to wait 3 days again. Yeah. But if this is different conditions, so they have a cold or flu one day, then they have food poisoning another, and there's days in between, they're actually strictly different, separate absences. So there should be 3 waiting days each time. So, good question. Don't know if you've got anything to add from your view.
Just from a sort of health and safety point of view, if someone's working and the fit note doesn't say light duties, technically you're good against the medical advice there. And if something were to happen, I don't know the PI answer to that. Yeah. So I think from a health and safety perspective, it's not a good position to be in. As I said, from a personal injury perspective, I don't know the answer to that. Yeah, beyond that.
Yeah, I think it is, and it completely get as an employee. You think, oh God, that is so laborious. They're telling me they're fit to work. Surely that's enough. I'm with you. Belt and braces says that they're not. Yeah, they probably accept some liability themselves by bringing themselves into work from a PI perspective. As we always say with capability matters, the employee's not a medical expert. We're not. So the classic where we've both been in tribunal and the judge asks the witness when they qualified for med school, that applies. Yeah, so exactly. Always consider. Perfect. Right. I think we got through a lot today. A lot of recaps. As I say, for listeners, bit of a break now coming up. We'll have something next week to go along with the Monday Morning Dispatch chat with Lawrence, and we're then both going to have a bit of a summer break. If anything comes up that's critical, we'll obviously report through various channels. But for the summer, Nils, it's goodbye from me.
And from me, see you all in the autumn.